Good morning and welcome to the Public Service Commission of South Carolina. It is Monday, September 11th at 10 a.m. We are here continuing the hearing in docket number 2023-89E. This docket concerns Duke Energy Progress LLC's petition for storm securitization financing order. Let's take a roll call of commissioners. With us virtually, we have Commissioner Irvin present in the hearing room. We have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carol Lee Williams, Commissioner Caston, and Chair Belser. As a continuation of a hearing, I'm not going to take a roll call of council, but I think we have everyone present. Do we have Mr. Lavonga virtually? Thank you.
Chair Belser, I'm here. Thank you.
Good morning. Thank you very much.
Good morning.
As we left things last, it seems like so long ago, was that Wednesday or Thursday? I can't even recall. But as we left things last week, the parties had filed a settlement agreement and needed time to get the agreement put down in writing and file settlement testimony. That has been done. So we'll recognize Duke to go ahead and proceed. Or Office of Regulatory Staff, Mr. Huber. Good morning.
Good morning, Madam Chair. I was going to ask if we could introduce the settlement agreement as a preliminary matter and provide an overview.
Yes, sir. That'll be fine.
Thank you, Madam Chair.
Where's my form?
Thank you, Madam Chair. And I do have copies of the settlement agreement. If a commissioner would like a hard copy, I'm glad to pass those up.
I think we all have them.
Okay. Thank you. Well, first, as I'd like to thank the commission for allowing the parties time and flexibility to continue to negotiate. And as you mentioned, the parties did have a stipulation on some issues that filed last week, and the parties have used the time that was granted wisely and have reached a comprehensive settlement agreement that was filed with the commission on Friday. And I also want to thank the parties for their efforts as we work together to negotiate and reach this comprehensive settlement agreement. And I'm glad to provide an overview. As you mentioned, the parties have filed settlement testimony as well. And just to be clear, this settlement agreement encompasses the stipulation that was filed last week, so it includes those provisions and as well as addresses others that had not been addressed in the stipulation filed last week. Some of the terms of the settlement agreement are as follows. Parties agree to stipulate into the record and waive cross-examination of certain pre-filed testimony. DEP agrees to establish a regulatory asset to defer upfront finance costs in excess of final estimates included in the issuance advice letter. DEP will accrue carrying costs on the regulatory asset net of ADIT at DEP's approved pre-tax weighted average cost of capital in effect at the time the deferral costs are incurred. The parties reserve their right to...
Is that microphone on, Mr. Huber?
It is. Am I not getting picked up? I could try to speak in closer. Does that help?
That helps. Thank you.
Okay. The parties reserve their right to review the reasonableness and prudency of those costs in the next rate proceeding. The settlement agreement contains a proposed resolution of the utility assessment fee, license fee, and sales tax issue that was discussed in testimony. The parties agree, DEP agrees that the time period for the commission to either approve the request under, this is the true-up process under SC Code 5827 1110 C4. The parties agree that that time period will be 60 days. However, ORS and DEP agree to engage in a good faith discussion to discuss reducing the time period from 60 to 30 days after completion of 3 semi-annual true-up periods. The parties have agreed to certain language discussed in ORS witness Collins' testimony being included in the storm securitization tariff sheet. The parties have agreed to provision resolving the issue of the 7.0% cap based on the average interest rate in the bonds and the securitization. The parties have agreed that From the date of the financing order, the company will defer and compound the return on storm cost, regulatory asset, ADIT, regulatory liability at its most recently approved pre-tax weighted average cost of capital, or WACC, until base rates are reset in the next base rate proceeding. At that time, the storm ADIT and the deferred return on storm ADIT will be included as a reduction to rate base, and the deferred regulatory liability will be amortized as a negative expense to return the deferred storm ADIT benefit to customers. The parties have reached agreement on certain language in the proposed financing order regarding third-party energy providers, if such legislation were never to come to pass in South Carolina. The parties also agreed to file a joint proposed financing order consistent with the settlement agreement as a change from the prior stipulation. The stipulation, the parties would file separate financing orders under the comprehensive settlement agreement. The parties have agreed to work together and file a joint proposed financing order. DEP has agreed it will obtain ratings from 2 rating agencies, those being S&P and Moody's. If the ratings from S&P and Moody's result in split bond ratings, DEP will seek advice and input from the bond advisory team on whether to obtain a 3rd rating from Fitch. There's a provision related to DEP having the flexibility to utilize a means other than an SEC registered sale if certain factors are present. That term is in greater detail in the settlement agreement. There's a provision related to DEP having the flexibility to utilize floating rate bonds if certain conditions are present. The parties have agreed the bond advisor team, again, or BAT, will consist of DEP and ORS. Underwriters in the DCA, Department of Consumer Affairs, will be invited to participate in BAT meetings, and the DCA will be provided the same information as formal members of the BAT. Under the settlement agreement, parties have agreed to ORS serving as the qualified independent third party, or QITP. The parties have agreed that they understand and agree it's appropriate for ORS to follow its statutory charge under SC Code Section 58410B and how ORS fulfills that role of QITP. DEP agrees to work with members of the BAT in the development of disclosures and the registration statement and marketing materials. The parties have agreed that after the issuance advice letter has been submitted to the Commission, but prior to noon on the 4th business day after the final terms of the storm recovery bonds are determined, DEP will be available to answer any questions to the Commission about the final agreed upon terms of the bond issuance contained in the issuance advice letter. And then if DEP, underwriters, or the QITP do not provide the certification contemplated by the securitization statute, or the Commission delivers an order to prevent the issuance of storm recovery bonds, DEP agrees to hold a BAT meeting for members and DCA to discuss any potential next steps, including whether to pursue another securitization financing as opposed to traditional cost recovery, and will explain it, and DEP will explain its final decision to BAT and BAT members and the DCA. And lastly, the parties have agreed to hold in abeyance all pending matters before the Commission. The parties agree that the Commission enters a directive adopting the settlement agreement. All pending motions will be considered moot. Again, I'd like to thank the Commission for allowing time to reach this comprehensive settlement agreement, as well as the parties' efforts. Parties have filed pre-settlement testimony. We had a status conference on Friday. Am I correct? As far as the procedure, with the BRF, the parties called the settlement witnesses first, and then the remaining witnesses would be available for questions following the settlement witnesses.
Yes, Mr. Huber, and I just wanted some clarification on that. Would the settlement witnesses come first? They will enter their any pre-filed testimony they may have into the record at that time?
Yes, Madam Chair. I think
Okay.
the parties envisioned they would take the stand once and they'd enter in all of their pre-filed testimony and be available for questions about all of their pre-filed testimony, including their settlement testimony.
Okay.
And ORS did file a verification this morning from Michael Seaman Wynn. The Commission, we thank
We've
the Commission
received
for
that.
allowing him to enter his testimony without appearing.
And just we have received that.
Okay. I think that concludes the preliminary matters. ORS had, I don't know if the company or Department of Consumer Affairs had anything.
Chair Belzer, no preliminary matters for the company. However, the company would like to make a few comments on the settlement at the appropriate time. Thank you.
Okay. Let's just, any additional comments from the DCA?
Not at this time.
Nucor, any additional comments to add to what Mr. Huber has presented?
No additional comments, Chair Belzer. Thank you.
Thank you.
Thank you, Madam Chair. And just, am I correct, as far as once the settlement witnesses have gone up, presented all of their pre-file direct, I would follow the normal procedure, company witnesses.
We'll go in that order.
DCA and then ORS.
Yes.
Thank you, Madam Chair.
So you're offering the settlement agreement?
Yes, thank you, Madam Chair. We would like to enter the settlement agreement as a hearing exhibit.
Settlement agreement will be marked for identification as hearing exhibit number 1 and received into the evidence of this case.
Thank you.
Thank you. Mr. Robinson?
Good morning, Chair Belzer, Vice Chair Powers, members of the commission. Again, Kamal Robinson here on behalf of Duke Energy Progress. First and foremost, I do want to echo Mr. Huber's comments. Thank you to the commission for allowing us the additional time to continue negotiating and reaching a comprehensive settlement as a result of it. As Mr. Huber indicated, we did use that time wisely and we appreciate it, as well as also thank you to the parties for being willing to continue to engage and reach not only a partial stipulation, but then ultimately a comprehensive stipulation covering all issues. Again, the company is pleased to have this comprehensive settlement covering all issues with all parties presented before the commission for requested approval. The settlement agreement is a compromise of all the positions advanced by the parties in this proceeding. With this agreement, parties have reached agreement on the terms that should be included in the commission's financing order, which will govern the structuring, marketing, and pricing phases of the proposed bond issuance. The structure of the pre-bond issuance review process as well, which includes the composition of the bond advisory team, including the involvement of the Department of Consumer Affairs, as well as the identification of the ORS as the qualified independent third party in this case, as well as the structure of the issuance advice letter process. Parties have further agreed on terms governing actions related to rate making and the administration of the storm recovery charge once the bonds are priced and ultimately issued as well. As evidenced by the signatories on the settlement, all parties were involved in the negotiation and all parties support the settlement. We think the settlement is a reasonable compromise to resolve all litigated issues in this proceeding among informed parties and should be approved by the commission, and provides a very strong framework to achieve the lowest storm recovery charges consistent with current market conditions as the statute requires. Thank you very much.
Thank you, Mr. Robinson. Are there any further preliminary comments or matters before we begin with testimony? Hearing none, Mr. Robinson or Ms. Athens will recognize you to present your first witness or panel. I'm not sure how we're going this morning.
Good morning, Commissioners. Thank you. We will be calling Mr. Heath first to present the settlement as he filed settlement testimony. So Duke Energy Progress calls Thomas Heath to the stand.
I do.
Good morning, Mr. Heath. Can you please state your name?
Ms. Athens, could you wait just a second? What are we handing out?
That should be his settlement testimony summary.
Okay. Is that coming to the commissioners?
It should be, yes.
Let's just wait until we hand those out, if you don't mind. Thank you, Ms. Athens. Did you take one?
Mr. Heath, can you please state your name and business address for the record?
Sure. My name is Thomas Heath. My business address is 525 South Tryon Street, Charlotte, North Carolina, 28202.
By whom are you employed and in what capacity?
I'm employed by Duke Energy Business Services as a structured finance director for Duke Energy and its subsidiaries.
And how many years have you been in structured finance at Duke Energy?
About 7 years in my current role.
And are you providing expert witness today on utility structured finance?
I am.
And did you cause to be pre-filed in this docket on May 31st, 2023, 47 pages of direct testimony in question and answer form and 3 exhibits?
Yes, I did.
Do you have any changes to your direct testimony and exhibits?
I do not.
And if I were to ask you the same questions today that appear in your direct testimony, would your answers be the same?
Yes, they would.
And did you also cause to be pre-filed in this docket on August 10th, 2023, 27 pages of rebuttal testimony in question and answer form and 2 exhibits, which were amended on September 8th, 2023 to only include 9 pages of rebuttal and 1 exhibit?
Yes, I did.
And do you have any changes to your amended rebuttal testimony and exhibit?
I do not.
So if I were to ask you the same questions today that appear in your amended rebuttal, would your answers be the same?
Yes, they would.
And did you also cause to be pre-filed in this docket on September 8th, 2023, 11 pages of settlement testimony in question and answer form?
Yes, I did.
And do you have any changes to your settlement testimony?
No, I do not.
And if I were to ask you the same questions today that appear in your settlement testimony, would your answers be the same?
Yes, they would.
Chair Belzer, at this time, I move that the pre-filed direct testimony, amended rebuttal testimony, and settlement testimony of Mr. Heath be copied into the record as if given orally from the stand, and that his 3 direct exhibits and 1 amended rebuttal exhibit be marked for identification as pre-filed.
Mr. Heath's pre-filed direct testimony will be entered into the record as given orally from the stand. Mr. Heath's amended rebuttal testimony will be entered into the record as if given from the stand, and Mr. Heath's settlement testimony will be admitted into the record as if given from the stand. Mr. Heath's exhibits 1 through 3, which were pre-filed with his direct testimony, will be marked for identification as hearing exhibit number 2 and received into the evidence of this case. Mr. Heath's rebuttal exhibit 1 will be marked for identification as hearing exhibit number 3 and received into the evidence of this case. And I don't think there was any exhibit with the settlement testimony. Is that correct?
That's correct.
Okay. Thank you.
Thank you, Chair Belzer. Mr. Heath is now available for commissioner questions.
Is he he's not going to give a testimony summary, is that correct?
I'm sorry, he is. Mr. Heath, do you have your testimony summary with you today?
Yes, I do.
Can you please read it for the commission?
Sure. Good morning, Commissioners. As I mentioned before, my name is Thomas Heath, and I'm a Structured Finance Director for Duke Energy Corporation, and a proud South Carolina citizen and a Duke Energy South Carolina customer. I'm pleased to appear before you today to discuss Duke Energy Progress, LLC's petition for a storm securitization financing order. In my direct testimony, I present the company's proposal to use storm recovery bonds to finance storm recovery costs as permitted by the securitization statute. Based on market conditions at the time we filed our petition, DEP estimated customer savings to be approximately $41 million, which would represent a reduction of approximately 24% as compared to recovery of these costs using traditional recovery methods to pay for storms. These approximated savings included estimated upfront and ongoing financing expenses, as originally detailed in my direct testimony and updated in my rebuttal testimony. As I first explained in my rebuttal testimony, parties to this proceeding agreed that recovery of DEP's storm recovery cost through the proposed issuance of storm recovery bonds would provide customers quantifiable net benefits as compared to the traditional method of financing, and that no party recommended the Commission reject the company's petition. Though certain issues existed over specific terms of the financing order and the pre- and post-bond issuance review processes. However, over the course of this proceeding, DEP was able to work with the Office of Regulatory Staff, Department of Consumer Affairs, and Nucor Steel, South Carolina, to reach a comprehensive settlement agreement pertaining to all contested issues in this docket. As explained in my settlement testimony, the parties have agreed upon the terms to be included in the Commission's financing order, which will govern the structuring, marketing, and pricing phase of the proposed storm recovery bond issuance. These terms include, for example, provisions in the financing order to govern third-party energy providers, provisions to grant DEP flexibility regarding the means of sale and the utilization of floating rate bonds, and provisions requiring DEP to obtain ratings from at least 2 rating agencies, and under certain circumstances, ratings from all 3. The parties have reached an agreement on the structure of the pre-bond issuance review process required by statute once the Commission issues its financing order, which includes the composition of the bond advisory team, identification of ORS as the qualified independent third party, and the structure of the issuance advice letter process. As a result of the settlements, the parties have agreed to expand the bond advisory team as originally proposed by the company to include DCA staff and counsel as participants. The parties have also agreed that ORS, whose mission is to serve the public interest, will serve as the QITP. Additionally, the parties have agreed that DEP will provide additional detail in the issuance advice letter under certain circumstances, and that the Commission should have the opportunity to ask questions about the issuance advice letter as necessary. The settlement agreement also includes terms governing actions related to rate making and the administration of the storm recovery charge, including how the storm recovery charges will be calculated, the true-up mechanism adjustment review period, and the calculation of carrying costs on deferrals requested by the company by ORS. In summary, the comprehensive settlement agreement represents a just and reasonable resolution of the issues in this proceeding, reflects a constructive approach to providing a framework to achieve quantifiable net benefits to customers, and the lowest storm recovery charges consistent with market conditions as required by the securitization statute, is in the public interest and should be approved by the Commission. This concludes my testimony summary.
Thank you, Mr. Heath. Mr. Heath is now available for Commission questions.
Thank you. Per the settlement agreement, the parties have waived cross-examination of witnesses. So, Commissioners, I see a light from Commissioner Thomas.
Thank you, and good morning. Good to have you here today.
Good to be here. Thank you.
So I'm going to just start out with some random questions, kind of high level. Interestingly to me, the law here, I view it as a little bit different than what we're normally charged with achieving. And I mean, it says in the first paragraph, will result in the lowest storm recovery charges. And that's kind of what's guiding me in my questions.
Sure.
And so to me, it's very, very important that every item in this stipulation takes us in that direction. All right, so let's start out. We'll talk a little bit about the means of sale.
Sure.
And again, getting back to that lowest costs. And there's mention of Rule 144A sales being a possibility. Can you explain to me how that could result in the lowest cost?
So that provision is included to be something that we should be able to be allowed to consider as we go through the next several months of this proposed transaction. As we sit here today, we believe that a fully registered transaction, fully registered and marketed to the broadest spectrum of potential investors, is the means of sale that will achieve the lowest storm recovery charges consistent with market conditions, not a 144A filing. What we're asking for is the flexibility to pursue a 144A offering if market conditions were to change over the next several months to a point where we believe a 144A transaction is a more favorable outcome for customers.
All right, well, please explain to me how a 144A sale could do that.
So 144A sale is going to be marketed to a smaller spectrum of investors. There are only certain investors who can participate in the 144A process. They have to be larger, they have to be more well-known, and meet certain requirements from the SEC. So we're already starting at a point where the number of investors that we would be able to talk to is smaller than if we did a registered transaction. So really, again, at this point, we think that a fully registered deal is the way to go.
All right, so again, please tell me, if you had to go that way, how would that result in the lowest costs?
I think it would be a reflection of specific dynamics in the market at the time that we were led to make that decision to pursue a 144A. Again, I don't think that a 144A is the optimal transaction at this point in time.
All right, so let me just tell you a little bit about how I would view a 144A sale. So let's just suppose me, I develop a condo project, and let's just say this condo project is $170 million in value, kind of about the same sort of money we're talking about here. And let's assume that this is maybe on the coast of South Carolina, and you have 170 units, and I'm hoping to sell those 170 units for $1 million each. And my understanding of the qualified investor is they're generally $100 million or more, and they're sophisticated. They've done this kind of thing many times.
Right.
So let's just suppose that this condo project has been evaluated by 3 appraisers, 3 inspectors, and let's just call it AAA rated. So this person comes to me with $100 million, and he wants to buy 100 units, but he wants to pay $950,000 each for them. So to me, he's coming in, with an upper hand, expecting a better deal. And so I'd be the one that pays for that. But in this bond issue situation, the customers would be the one paying that price. Is that correct?
That's correct. I mean, the recovery of the bond, the repayment of the bonds, and the interest costs and the financing costs are being borne by customers in this transaction.
So in the scenario that I just threw out there, it would cost the customers more, not less.
Yes, potentially. I mean, that's why we're saying that at this point, we do not believe a 144A transaction is the method of sale that's going to get the lowest storm recovery charges consistent with market conditions for this financing.
All right. Let's talk a little bit about floating rate bonds. And in my opinion, those are more risky to a potential investor. Could turn out that they're going to be paying a higher interest rate or a lower interest rate. So again, that would mean that a potential investor would want a premium.
Correct.
Which again would mean that customers would pay more.
Correct. And there's on these bonds, for predictability of the charge, the repayment of the bonds and the interest needs to be readily predictable, and that's not the case in a floating rate instrument. So there would likely need to be some sort of interest rate swap involved to then fix the interest rate, and there would be a cost to doing that. And there's also introduction of credit risk from the bank into that structure as well. So again, as we sit here today, we do not believe floating rate bonds are the way we would issue the bonds, the storm recovery bonds in this transaction. We would pursue fixed rate. But again, the request is around flexibility, that if market conditions were to change in some manner over the next several months that we could at least think about and pursue with advice and input from the other members of the bond advisory team, whether a floating rate structure made the most sense. But as we sit here today, we believe that fixed rate is going to get the best outcome for customers.
All right, I heard you mention higher risks, higher costs, and so for those reasons, I'm concerned about moving in the direction of floating rates.
So again, we're not saying that we are going to issue floating rate bonds. We're asking for the flexibility to be able to pursue issuance of floating rate bonds if we believe, in consultation and advice and input from the other members of the bond advisory team, that would be the optimal structure at the time we're ready to go into the market. We would only pursue that route if we felt that was the most beneficial structure to customers, and that we could issue our certification that's required by the statute, that we've achieved customer benefits and the lowest storm recovery charges consistent with market conditions. So in whatever structure we put forth to this commission, we have to be able to certify to those two statutory objectives, and that's the deal that we're going to put in the market, is the deal that can achieve that benefit for customers.
All right, well, let's just suppose that the floating rate bonds do come into the picture, and let's just suppose that interest rates increase over the next few years. So let's just suppose that these are issued at 5%, but 4 or 5 years from now, the rate would be 8%. Mm-hmm. So there, I guess, two thoughts there that I have. Number one, how does that 7% cap come into play? And number two, how does this end up continuing to flow through to customers, where customers are not now paying more because rates are now floated up to 8%?
Yeah, so again, if we did a floating rate bond, there would likely need to be some sort of interest rate swap done. That would effectively,
and that costs money.
It does, right? And there'd be a swap done to put in place to fix the interest rate, and that measurement against the cap would include the fixing of that interest rate through that interest rate swap.
And those extra costs would be flowed through to customers.
They would, but again, we would not do that transaction if it was not more beneficial to customers than compared to doing a fixed rate transaction.
All right,
Commissioner Thomas, would you mind if I followed up on that?
please.
Good morning. Mine will be more general questions. Is there something happening in the market that tells you you need this as a backup? Are you being told,
No.
What's the motivation?
As of today, no. So in the deals we did in Florida, the deal we did in Florida and the deals we did in North Carolina, both of those had this sort of flexibility in the financing order. We did not pursue. We did fully registered deals. We did fixed rate bonds in both of those transactions. I'm not even aware of a storm or a recovery bond like this that's been done with floating rate tranches, but the flexibility has been there for that option to be pursued if that is going to provide the greatest customer savings.
So these were provisions that you had included in North Carolina and Florida.
Yes.
Is there anything happening in the market that tells you that this is something you're going to want to have available? Or is it just
I don't see anything in the market, but again, flexibility for these types of transactions is key. Any sort of restriction in a financing order that limits our ability to pursue the best outcome for customers can be detrimental to achieving customer savings. So we're just looking for the appropriate level of flexibility to pursue the transaction that is going to provide the best outcome. And
you may have answered this to Commissioner Thomas, but what are under what kind of conditions would you want to be using either the floating rate bonds or the 144A?
So the 144A would be more if there's just a disruption in the public capital markets through could be global events, could be something that's happened here in the United States specifically, but something that's disrupting the predictability and the stability of the capital markets. And if we believe that there's a potential to go talk to a smaller group of customers, which is what a 144 is going to lead us to do, that could get us something that's more predictable and more stable. That would be why we would pursue a 144A. On the floating rate bonds, it would be, I think if there's, but because we're going to swap it and really convert it, we would need to swap and convert it back to fixed rate. There's really, I've struggled to find what would be something that tells us to do a floating rate bond today or at any point really in the future. But it could be if there's projected to be continued increases in interest rates. But even then, I mean, if you can get a fixed rate today and you're expecting interest rates to go up in the future, you're better getting the fixed rate today. So it's difficult for me to come up with a scenario that says we need to do a floating rate bond today. Ms. Niehaus may be able to elaborate on that more, but.
Okay. Thank you very much. I appreciate it, Commissioner Thomas.
Madam Chair.
Are you following up on these questions, or are we back to Commissioner Thomas?
I was just going to ask one question, then turn it over to
Okay,
Commissioner
thank you.
Thomas.
Commissioner Vice Chair Powers?
Good morning. Looking at your two-page summary that we got this morning.
Yes, sir.
You talk about ORS as a qualified independent third party, and that, of course, as we know, their mission is to serve the public interest.
Correct.
Would not part of that public be ratepayers?
Absolutely, yes. Yes.
Well, how does that make them independent when they're technically representing some of the people affected by this?
So I look at it as being independent of giving a voice that's independent from the company is really how I would interpret that independent role. So providing comments on all aspects of structuring, marketing, and pricing that are independent of the company's view, and advocating for customers throughout that process.
Does the process, is it independent if Duke has people at the table rather than a really independent group making this decision?
I mean, the ORS is independent of Duke.
I know, but you also say that Duke should be part of the advice letter and being on the bond advisory team. Mm-hmm. They would not be an independent party. They're there for Duke's interest, right?
Well, Duke is the issuer of these bonds. I mean, they're going to be issued by a special purpose entity that is going to be a subsidiary of Duke Energy Progress. That's the entity that is facing the market and selling these bonds to potential investors. And so Duke has to be in a position in that transaction.
Okay, thank you, sir.
Thank you, Vice Chair. Commissioner Thomas, please continue.
Well, I think I'll follow up there on Mr. Powers' questions. So in terms of ORS, the public interest, and the public interest, it seems to me, includes not only customers, the general public, perhaps the utility, and so I mean you can say that they are independent of the company, but ORS's general charge is the overall public interest, which in my opinion does include the utility. So can you help me understand how they switch from the public interest that doesn't include the utility to being truly independent?
And I mean, I'm not as familiar with rate case proceedings in this state, but I'm not aware of ORS advocating for Duke's position in proceedings.
No,
I know
I'm
we
not.
reached settlements on matters kind of like we've reached settlements here, but I don't believe that ORS is a advocate of Duke Energy Progress.
All right. Let's go back to the 7% cap. So, is this not some sort of an arbitrary number? I mean, you've talked about the possibility of using floating rate bonds, which I think we would both agree that those could end up running above 7%. So how does that reconcile the 7% cap with floating rate bonds or market conditions or anything else?
So if there were to be floating rate bonds, in order to have the charge to be predictable and the revenue requirement to be relatively fixed over the term of the financing, there would have to be interest rate swaps to convert those floating rate bonds to fixed. And so again, that we would use if we did a floating rate issuance, we would use the impact of those swaps in determining the weighted average interest rate on the bonds and measure that against the 7%. The 7%, I think, was originally suggested by an ORS witness, from witness Colin. So in my direct testimony, we were trying to show some sensitivities to the savings level that we had shown in witness Smith's exhibits. So we showed $41 million of savings, 24% benefit to customers compared to traditional recovery. And there was an interest rate on an indicative interest rate on the bond structure at that point. And so what we're trying to show is, if interest rates were to continue to increase over the next several months, what would that do to customer savings? So we showed a sensitivity of, I think, 150 basis point increase over the structure that we laid out. And we also showed kind of a break-even number. And so the break-even, my recollection, is about 7.75%. So we said if interest rates were to go up, continue to go up over the next several months and get to that point, if it ever got to 7.75%, there would be zero savings for customers for doing the storm recovery bonds compared to traditional recovery. And so in witness Collins' testimony, he kind of suggested the 7% as a level to still provide some level of savings. I think that 7% equates to about 10% savings compared to the 24% that we showed in the petition and in my direct testimony. And so it's really a marker that we've agreed to put in place to kind of pause and to have further discussions and reflection, and to come back to the commission and say, here's what interest rates look like today. They're 7.1% or whatever that we would think they would be at that point. And here's our plan. We think it either makes sense to continue forth because there still is customer savings to be obtained, or it does not make sense to continue at this point. We would make that decision if we ever saw the indicative interest rate getting close to or exceeding that 7%. We would have another or more discussions within the bond advisory team construct and develop a recommendation for coming back to the commission on whether we should proceed at that point in time or not.
All right. So, in the discussions in the stipulation in connection with that 7% cap, it uses the term for informational purposes. So I don't really understand why for informational purposes is in the stipulation in connection with that cap. Can you help me with that?
So that is that in our issuance advice letter process, we would talk about, because the letter already is going to say what is the interest rate on the bonds. And if there's multiple tranches of bonds, what is that weighted average interest rate? And so what we have agreed to in the settlement is to provide some context around how did we get to the interest rate that we got to? What other comparable securities were we looking at the time? And what is our interest rate or yield on the bonds that we priced compared to those comparables, and why they may be at spreads that are equal to or maybe spreads that exceed those comparables.
All right, well, let's talk about the bond team a little bit. So I noticed that DCA has been excluded from the bond team, and DCA is the entity that represents the interests of the ratepayers. And I find it interesting that they were purposefully, or well, they're maybe not purposefully, but they're not named as part of the bond team. So how did that happen?
Yeah, so there's, in my mind, there's very little distinction between ORS's role as an official member of the bond team and DCA as an invited member of the bond team. They're both going to receive the same information. So when we get into the rating agency phase of the transaction, we will share our proposed rating agency presentation materials with both ORS, with DCA, and we will solicit their advice and input on whether those the context of that presentation is appropriate for sharing with the rating agencies. We'll accept their feedback, or we'll consider their feedback in the same manner that we'll consider feedback from ORS. Same thing when we start putting together marketing books, or when we draft the registration statement. They're going to be provided the same information that ORS is, and they'll have the same voice really to provide their advice and input to those materials. So they're in this as part of the settlement. They're invited members of the bond advisory team. Their role is, a lot like the underwriters, as being both of those are invited members of the bond advisory team. They'll be in every meeting that we have, or at least invited to every meeting that we have, and they'll have the same opportunity to provide advice and input that ORS does. So in my mind, there's very little distinction between ORS and DCA, other than ORS is going to be providing a certification in their capacity as the QITP.
But at the same time, we're talking about the entity that represents the interest only of the customers. And the agreement, I believe, names as part of not the team, but having a say. It does name DCA. It says their staff and their attorneys. It does not name their consultant. Whereas I think Duke has a consultant named, and maybe ORS, I can't remember for sure. But I did notice that DCA's consultant was not named as having any input. And in my opinion, it's important for DCA, the customers, to have as strong of input as the company has, or ORS. And their consultant may be very qualified to be a member of that team. So I'm concerned that they are not included. And thus far, you haven't said anything that makes me feel a whole lot better. But I'm here to listen and learn, so I'd appreciate it if you would continue to help me understand.
Sure. I don't know. I'm not sure what the terms of the engagement with DCA and their consultant is. If Mr. Rothschild is going to be involved throughout the pre-bond issuance process or not. If he is still involved, I mean, he'll be able to look at all. I'm sure that he would be able to look at the same materials if they have them as part of the bond advisory team. I don't see why they would not be sharing them with him.
Commissioner Thomas,
Yes, sir.
could I ask a question just to
Please.
clarify for my benefit, if I may? Because I'm a little confused also, I guess, on the response relative to the DCA and ORS role. Relative to ORS, what does public interest mean to you?
My understanding is that they are representing the voice of customers.
Is people who aren't customers part of the public interest in your view?
I would presume so, yes, but I'm not sure how non-customer people who aren't customers of DEP would have much at stake in a storm recovery bond transaction for customers of DEP.
So if I'm understanding what you're saying, the public interest, in other words, there's no distinction between ORS and DCA. So my first thought would be, well, why do we have them both if they both serve the same role? Is that what you're saying?
No, I'm not an attorney, so I don't know what the statutory distinctions necessarily are between ORS and DCA.
Well, it's pretty clear, I believe. But having said that, if ORS's role is just the customer, then do they serve an antagonistic role to the utility, or are they supposed to look after the utility's interest also?
I mean, I said earlier, I'm not aware that ORS advocates for positions of DEP. I mean, my knowledge in this proceeding and in my more limited knowledge in rate case proceedings before this commission is that DEP and ORS are usually on opposite sides of issues, and there may be settlements that are negotiated to achieve outcomes that are workable and reasonable for both parties. But I don't know that ORS advocates for Duke Energy.
Chair Belzer, I'd like to
Ms.
point out.
Athens. Go ahead.
I'd like to point out that ORS will be available to answer any questions.
You're off. There you go. You're off again.
I appreciate that, and I will not go any further down this, but I wanted to hear what Duke Energy Progress understanding a definition of this is. I think that's important.
Let me just ask a question and follow up, okay? The bond team. Are the members of the bond team, and I think you indicated in your summary that DCA will be a participant.
Correct.
Will they be able to provide meaningful collaboration and will DEP listen to what they're saying? I mean, what assurances does the commission have that DEP will actually give thoughtful, good consideration to input from ORS and DCA?
We will absolutely listen to all voices that are expressed in the bond advisory team, whether they be from ORS or DCA. Like we will value the input that they bring to the table. We will consider it, and we will decide courses of action based on the feedback we receive from all parties.
Okay, and then let's look a little further down the line if we do the issuance advice letter and things have maybe changed a little bit that require explanation. Will there be explanation provided to the commission why DEP may have chosen a certain course to pursue if DCA or ORS had recommended something different?
We will describe the significant actions that were taken in the structuring, marketing, and pricing of the bonds. So rating agencies, how we got AAA ratings there, what kind of marketing efforts that we did, how many investors we talked to over the course of how many days, and those sorts of things. If there are you know, throughout that whole deliberations of the bond advisory team, if there are points that ORS or DCA feel very strongly about, then they should make us known that these are points that they feel very strongly about, and that if those are to the point where they're strong enough to maybe jeopardize their support for the transaction, then that makes us listen more closely, I guess, to their thoughts.
Let me ask a question. Once this, I'm assuming that we approve and we're moving forward, and once this, the bond team's going to have work to do before you actually start with the underwriters and have a prospectus or whatever
Absolutely.
documentation.
Yes.
At what point does SEC rules require things to be pretty closed in-house, not discussed outside? I mean, I think that once a prospectus is filed or what? Because I reckon that my concern is with communicating with the bond team, what information is going to be able to come back to us in the issuance advice letter? Are those discussions with the bond team going to be black boxed, I reckon?
They're going to be within the bond division. I view them as being very collaborative discussions. My experience in both Florida and North Carolina was that we would every stage throughout the process, we provided all materials to the members of the bond advisory team. We had regularly recurring meetings, and we set an agenda for every meeting and said, here's what we're going to be talking about today. These agenda items, some of these are new items, some of these are follow-ups from last week or last month or whatever. And those are very constructive and collaborative sessions. The report out of the transaction, really, of everything that has transpired through those bond advisory team meetings and all of the aspects of structuring, marketing, and pricing, is the issuance advice letter. Right? So it's going to say what's the term of the bonds, what's the principal amount that we issue, what's the recovery period, what's the interest rate, the amortization schedule, what is the revenue requirement for the 20-year period, because once these bonds are priced, then the revenue requirement is relatively fixed. Right? We've got scheduled amortization, we've got fixed rate interest. The only thing that's really variable is the level of ongoing expenses. Right? Rating agency fees, ongoing trustee fees, those sorts of things, and those are relatively predictable. And so we'll show you that 20-year revenue requirement. We'll have our quantifiable benefits calculation in there that shows on a net present value what is the level of customer savings. We'll have our certification in there, and then we'll have a letter, or a part of that letter will then detail out all these different actions that were taken throughout the pre-bond issuance review process. So again, we worked with the rating agencies. We stressed the important aspects of DEP and its service territory that enabled us to get a AAA rating. We, again, marketed to X number of accounts over however many days. And then we'll have the informational data that we talked about a few minutes ago in terms of how did we view these bonds, how did they price relative to comparable securities, and what factors may have led to equal pricing or slightly wider pricing if that happens to be the case. So all of that's going to be, and that issuance advice letter will be reviewed by ORS and DCA as part of the bond advisory team process as well. So they will have they will get a draft of the issuance advice letter. We'll lay out a preliminary draft. I think it's 2 weeks, maybe 3 weeks before we put the transaction into the market, and they'll see what we're thinking at that point in terms of what are we going to say in our certification and in the issuance advice letter, and they can advise and provide input on that, and then we'll share the final with them as well at the point it's filed or before it's filed.
Okay. I don't want to go too much further because we're still on Commissioner Thomas, but I just wanted some clarification on that, and I thank you. Commissioner Thomas, you you're still up. Thank you for allowing me to interrupt.
Thank you. I appreciate that. I think at this point, I'm going to just ask one more question, and then I'm going to allow the other commissioners to jump in. So I have some concerns about the underwriters participating in all of the bond team meetings. To me, very, very clearly, the underwriters have their own strong interests, and it just seems to me that perhaps the bond team should be, let's just call it, negotiating against the underwriters in order to be sure that the lowest interest rate, the lowest costs, are how this thing plays out. So can you help me understand? Does that make any sense?
Yeah, I think so. I mean, I think I would say just because different parties have different perspectives in the transaction doesn't mean that that's ultimately gonna be a detriment to the transaction. What we did well, I'll back up a little bit. Before, we use underwriters at Duke Energy all the time. We issue billions of dollars of first mortgage bonds for our operating companies and unsecured bonds at our holding company every year. We've got about $75 billion worth of debt outstanding right now, which is in the ballpark of the total debt that's ever been issued in these cost recovery bond space since the mid-1990s. So we deal with underwriters frequently, and we know that we know what their perspective is in a transaction. We don't listen to their advice exclusively. We have our own expectations of a given transaction, and we're not afraid to challenge underwriters, and that won't change in this transaction either. In North Carolina specifically, we did have sessions of the bond advisory team where we went to almost like an executive session. So we had everybody called in for the first, or joined in on Teams or whatever the venue was, for the first hour of the conversation. And then we dismissed the underwriters and we continued to talk as a group, excluding the underwriters, for another 15, 20, 30 minutes, whatever it happened to be. So we could do the same thing here, and we probably likely would do the same thing here to ensure that we all have an opportunity to kind of reflect upon as a group what we heard from the underwriters and what our perspectives, each of our perspectives, are on what we just heard in the context of that broader discussion.
So do you believe that this stipulation allows, let's call it what you just said, dismissing the underwriters from the meetings?
That the way the bond advisory team operates is going to be the call of DEP and ORS as the kind of the full participating members, if you want to use that term. And so if that's something that we want to talk about, and with ORS as we begin this process, then yes. But I would say we're open to that. We would be very supportive of that.
Okay. So has the underwriter been determined at this point?
No, and I would say underwriter or underwriters. So we have engaged Goldman Sachs at this point as our structuring agent to help us through this phase of the transaction, providing testimony and helping us with preliminary modeling and structuring thoughts. But we have not made a decision on underwriters at this point.
So do you believe that it would be wise to, let's call it competitive bidding by the underwriters as to who may end up being the lead underwriter, who may be the team? In other words, they basically have to fight for the business. Do you believe that that should be part of choosing the underwriter or underwriters?
It could be appropriate. I mean, we did an RFP for the structuring agent role, and we decided on Goldman Stanley as the structuring agent in this phase. Some of our RFP did ask about underwriting capabilities, and so we took that into consideration when we made the decision. but our engagement with Goldman Sachs is clear that they are not guaranteed an underwriting slot. But we do believe it would be efficient for the structuring agent who's been involved for, at this point, several months now at least, in helping us with testimony and has party to these deliberations would be in a good position to be a lead underwriter. But again, that decision's not been determined at this point.
Okay. And just a little clarification, perhaps I misunderstood, but I thought I heard you say Goldman Stanley.
I'm sorry, Goldman Sachs, sorry.
Okay, thank you. And I think I'll take a little break at this point and let somebody else ask some questions. Thank you.
Commissioner Justin Williams, I thought I saw your light earlier. Okay. Commissioner Carolee Williams.
Thank you. Thank you, Chair Belzer. I want to go back to the conversation about the bond advisory team.
Sure.
And what I heard you say was there's little difference between the roles that you saw DCA and ORS playing on the bond advisory team. Is that correct?
Yes.
Why not put DCA on the bond advisory team?
They are. I mean, they are an invited member of the bond advisory team.
But there seems to be some distinction in difference. Is there? Maybe I've misunderstood it in the evolution.
The main difference is that ORS, in their role as the QITP, would be providing a certification as to achievement of the statutory objectives, the quantifiable benefits and lowest storm recovery charges consistent with market conditions at the time the bonds are priced, and DCA is not obligated to provide such certification. That's really the big difference in my mind.
I'm not prepared enough to pull the settlement agreement and read to you what it says, but are you saying that you perceive DCA? Thank you. So page 9 of your testimony identifies number 1, DEP, number 2, ORS.
Mm-hmm.
And then it suggests, to my mind, a distinction that there's a different category for the underwriters in the council and DCA.
So again, that distinction to me in terms of ORS being an official member of the bond advisor team is that we've also agreed they will serve in the role of the QITP, and that they would be providing a certification. DCA would not. The underwriters provide a certification, even though they're not official member of, formal member of the bond advisor team, because they are the party who is working closest with DEP to actually place the bonds in the market. So they need to certify that the transaction that they help sell does indeed achieve the statutory cost objectives.
Would you agree that you previously talked about DEP or Duke and ORS running the process, including the idea of excusing the underwriters? So DCA was not included there. Is that a difference in, a distinction in what DCA can do versus what ORS can do?
Again, the big difference in my mind is that ORS is going to be certifying to the results of the transaction. And so, but in terms of the materials that are being provided, I mean, you can look on page 10 that
right.
DCA is going to be invited to all meetings. They're going to be provided with the same information provided to formal members of the bond advisory team. So they're going to have the same information. They're going to have the same ability to provide advice and input. But we've not, as part of the negotiations, they were not asked, either not asked to or did not agree to provide certification.
Okay, so the certification is the only difference that you see.
Yeah, I think so. Yeah.
Do you have experience? You clearly have experience with Florida and with North Carolina. Were there comparable offices to the DCA, and how were they involved in those two cases?
So I don't recall there was a separate entity that, like a DCA. There were certainly parties in both North Carolina and in Florida that were advocating for customer interests.
That were part of the bond advisory team?
Correct.
Looking at your settlement testimony, and this was true in the stipulation as well, talk to me some about and this is page 5, but it's the idea that you would use, I'm not seeing it right this second, S&P and Moody's, and you would only go to Fitch if you needed to.
Sure.
Is there a cost involved with the number that you are going to? Why are you deciding to put this out to 2 entities and only go to the third?
Sure. So there's an element of cost there, right? Each agency is going to charge fees to rate the transaction. And so if we can get a transaction done and have the best outcome for customers by only using 2 agencies and paying the cost of 2 agencies, we're better off, because that's less that we have to finance and less that customers have to pay for, right? So as a corporation, Duke Energy currently only has ratings from Moody's and S&P. And so these bonds, they have structure to them, right? So they're sort of a structured product compared to Duke's first mortgage bonds or unsecured bonds at the holding company. But our goal here is to market these and stress the credit features of this bond, and to really present it as close to a Duke Energy offering as we can. Okay, and so Duke Energy has 2 ratings, only S&P. We think that's another factor why we only want to have this deal rated by Moody's and S&P. If we have a standalone deal sponsored by Duke Energy that has a Fitch rating when nothing else from Duke has a Fitch rating, it could lead to questions about why do you view this differently.
That was interesting. Thank you. I think, let's see. You may have covered this before, but I want to make sure we get it more clearly.
Sure.
If there's a difference of opinion on the bond advisory team, talk to me some about how that worked in Florida or in North Carolina, and how you plan for it to work in this circumstance.
Sure. I mean, the goal of this bond advisory team, and what we'll work toward throughout the whole proceedings, is to make sure that all the parties, company, ORS, DCA, all have as much alignment as possible as we can have through every stage of the structured marketing and pricing. So we draft the registration statement and we circulate it for review. We want to make sure that we all agree on the content and the disclosures that are in there as much as we possibly can before we file that with the SEC. When we put together rating agency materials and talk about DEP and its service territory and all the things that make this bond worthy of a AAA rating, again, we want to have as much alignment between all those parties as we can. Same thing when we get into the marketing presentations. We put together our book that we're gonna give to investors and put out on a secured website. Again, we want to have as much alignment on the disclosures that are in that marketing book, again, around what is making this bond as strong as it is. And so all that's going to be done through a collaborative process. So I don't really see there's going to be significant disagreements. We're all going to be trying to get the best deal for customers in this transaction, right? We've all got to provide. You're going to get certifications from the company, from ORS, from the underwriters as to achievement of the statutory cost objectives. And for us to be able to do that, we all need to be in as much agreement as we can about all of those aspects. And so, our goal is to make sure we're all on the same page and that we're all comfortable with all of those materials and all of those decisions that are made so that we can all give our certifications at the end of the day.
And what if you're not?
If it's something that rises to the level, particularly for ORS, where they feel that this is going to impact their ability to issue their certification, they should voice that in the context of a bond advisory team meeting. And we will work as best as we can to address that situation to make sure that we are in alignment and that we're not having significant disagreements. So those are all debates that happened. I'm trying to think back to Florida or North Carolina, if there were points where we were just completely opposed. There's nothing that stands out that we were just far apart on an issue or on a disclosure or on a matter. There might be some haggling, if you want to call that, over particular phrasing or things like that. But as long as we don't view that those types of things are putting unnecessary risk on us as the issuer of the securities, we're going to be open to accepting that advice and feedback and making those disclosures what they need to be.
Thank you. I appreciate that. I am going to take a pause in my questions and turn it over to another commissioner.
Commissioner Caston?
Thank you, Madam Chair. Mr. Heath, relative to, I guess, Act 227, the securitization statute, do you agree the Commission's role is to assure the lowest cost charges for the customer?
It's to ensure that there's quantifiable benefits and that the lowest storm recovery charges based on market conditions are achieved.
Somehow I felt like that was a yes or no, but I'll accept that. I guess those words can mean different things to different people based on market conditions and everything else. So with that in mind, and along the lines of the questions that Commissioner Thomas and Commissioner Carol Lee Williams have asked, as I would look through the stipulation this weekend, the bond advisory team, I think it's called the BAT. Mm-hmm. And you've talked about it a lot here. Mm-hmm. But I saw a lot of terms about discuss, and I get it. Does the bond team have to agree on a solution or a matter?
100% agreed? No.
If, remind me again, who is on the bond advisory team?
So I guess more formal members are DEP and ORS, and then invited members are the underwriters and DCA.
So there's only two formal, you're saying, and the others are just, y'all come on in. Is that what that means?
Absolutely not. No.
Then I'm not understanding it then, so I'm going to have to get you to clarify it, because the two formal members are Duke and ORS. So if the two formal members don't agree, what does that mean?
Well, again, as I mentioned a minute ago, if ORS disagrees with DEP about something that is significant, in their mind it's significant and it is likely to impact their ability to issue their certification, then they need to tell us that, and we need to work toward a workable solution. We're not going to be dismissive of anyone's perspective or advice and input. I mean, our track record from our prior deals is that we listen to the advice and input that's provided. and we make decisions that are going to enable all the parties to issue their certifications as to the statutory objectives.
Well, I'm going to let you elaborate more on, I guess, the official members and then the ex officio members, or however you want to classify it. I'll let you classify it. Tell me who those members are. And can you do that now?
I'm not sure I understand what you're asking me there.
Who's on the bond advisory team?
So again, if following formal members, DEP and ORS, invited members, underwriters, and DCA. But DCA, as it says on page 10, is going to get the same information that the formal members of the bond advisory team get, and they're going to be able to provide advice and input, just like ORS does. That's the construct of the bond advisory team. If you go back to my direct testimony, we talk about the bond advisory team providing advice and input to DEP. And that's whether you're a formal member or an invited member.
So if the invited members don't agree with Duke and ORS, who wins?
Depends on, so the underwriters are going to be providing a certification. And so, again, I would say the same thing that applies to ORS would apply to the underwriters. That if there's something that they believe is jeopardizing or negatively impacting their ability to issue a certification, they need to tell us that very clearly, and we need to work toward a reasonable solution. The fact that DCA may not be providing a certification really does not change my perspective either. So we're going to listen to their advice and input, and we're going to evaluate it and make decisions based on the advice and input from all parties. Again, whether they're formal members or whether they're invited members.
Then if their advice is so important and you're going to listen to it, why can't DCA and these other invited members be on the formal BAT? Why is that a problem?
Chair Belzer, I apologize for interrupting. Just like to
This
make a
isn't
comment.
your witness, Mr. Robinson.
Well, it's a shared witness, Chair Belzer, but I think this would be an important thing to convey at this point.
Are we getting into settlement discussions?
So we are, Chair Belzer, but I do want to just make the indication that Mr. Heath is able to speak to the roles of the parties. If there is a discussion around why the particular composition, he cannot speak to that particular component, which I think is what's being raised by the commission. So if the commission would like some clarity on that, I'm happy to provide it. But Mr. Heath cannot speak to why that negotiated process began and struck.
Then who can again? I'm sorry.
Is there going to be a witness that can discuss that matter?
Yes, there will be a witness. There will also be the ORS and the DCA as well. And again, I'm happy to also provide that feedback as well if you'd like.
Okay.
I simply want someone to, whoever can answer that question clearly, succinctly. That's all I ask.
If there's a witness, if you can identify them at some point, if it's a matter that needs to be addressed by council, just let us know that, and we'll hear from all council on it.
Thank you, Chair.
Thank you.
Thank you, Madam Chair. As I look at the also means of sale, and I noticed it talks about the statutory cost objectives. When I think about Act 27 and having read it, are those, in your opinion, Duke's opinion, statutory cost objectives or statutory cost mandates?
I believe they're objectives is the term that we use, right? I believe that's the proper characterization. Again, the first level is quantifiable benefits. The second level then is lowest storm cost, lowest storm recovery charges consistent with market conditions.
That's Duke's interpretation. Is that what you're saying?
Those are the statutory objectives.
I understand.
And we say that we believe those are objectives, and we're going to certify to those objectives that those were in fact achieved.
I'm going to take a break from questions for a moment. I want to look at some more stuff.
Madam Chair,
Commissioner Urban?
thank you. I want to talk with you briefly about what happened in Florida. You mentioned that earlier. In fact, when this came up with Duke Energy Florida in a securitization docket, there was a member of the Florida Public Service Commission that served on the advisory team, was there not?
Correct.
And also in North Carolina?
Correct also, yes.
And so I also want to ask you, if you would, to indulge me in a minute while I read from the statutory requirements for securitization bond issuance. And I'm reading from subsection A, quote, such issuance advice letter shall be in the form approved in a financing order and include the final terms of the storm recovery bond issuance, upfront financing cost and ongoing financing cost. Such issuance advice letter should include a certification from the electrical utility, the primary underwriters, and a qualified independent third party designated by the commission as a condition to closing, end quote. Did I cite that provision correctly?
I do believe so, yes.
Thank you. This is a complex area of the law as it relates to issuance of storm securitization bonds. Would you agree with that?
Can you ask that question again? Sorry, I'm not sure I heard it.
Just to talk about qualified in terms of participating in a process like this, isn't it reasonable to require that first of all, doesn't the statute say we get to pick the qualified independent expert rather than Duke?
The statute does say that, and we're asking you to approve the settlement.
I understand, but what you're asking us to do is to do something contrary to the statutory law in South Carolina, because we the commission clearly get to pick the independent qualified expert, and we also, of course, logically have to determine that that expert is in fact qualified. Has anyone from the Office of Regulatory Staff ever participated in a securitization bond issuance or advice letter before?
The ORS would have to speak to that. I'm not aware of it. Well, not aware that they have.
I'd be surprised that anyone has participated, because this is the first docket in South Carolina under our new act. So, but the first question is they should be independent. And some of my fellow commissioners have talked about that already, so I won't go back into that. But they also have to be qualified. Otherwise, they're not going to know what questions to ask or what terms to ask for, are they?
I do believe that the ORS has engaged a consultant who does have experience in these bond issuances in the past.
Well, why isn't that being disclosed to us? Because if there's a consultant that's going to be at the table, we'd like to know who it is.
ORS would, I guess, have to speak to that.
Madam Chair, questions have been answered.
Just a moment, Mr. Huber.
Madam Chair, that is a question for RS. We have.
Mr. Roden will be able to speak to that.
Yes, Madam Chair.
Thank you, Mr. Huber.
I'll ask him as well then. But back to the stipulated settlement agreement. why is the commission being slighted in terms of being able to pick our own independent qualified expert to participate? That's what the statute requires.
The commission's not being slighted in any way in this settlement or in anything that we've put forth in this petition. The commission is the ultimate decision maker in this proceeding. So we will provide an issuance advice letter that you will review and make a determination on, and that cannot be understated in any way. That your role here is critical, and the issuance advice letter that you will receive is the culmination of everything that's going to be happening from receipt of this financing order into the pricing of the storm recovery bonds. And so your role here is not being limited or reduced in any way.
Well, the statute says we get to pick the independent qualified experts. You've already agreed with me on that point. Nobody's even asked for our input on who that independent qualified expert should be. And you rush to a settlement agreement that it's just kind of ignores that provision of the law. And I'm wondering why that is. Because in North Carolina and in Florida, there were commissioners on the team. And I understand we have some ex parte rules in South Carolina that are unique to our state, but we certainly, in the General Assembly in its wisdom, understood that and gave us the authority to appoint who we deem independent and qualified as an expert to participate in this process. Wouldn't you agree with that?
We're asking you to approve a settlement where we have agreed to the ORS serving as that qualified independent third party. We're asking you to approve that settlement in its entirety. So I guess if you didn't like the settlement, then for whatever reason you would not approve it.
No further questions.
Thank you, Commissioner Irvin. Commissioners, further questions? Commissioner Thomas?
Thank you. I have just a couple of follow-up questions for now. So when you were answering a question by Commissioner Carol Lee Williams, you said something to the effect that the company will issue the bonds and takes all the risk. And first of all, my understanding is that it will be a special purpose entity that will be issuing, not the company. And secondly, what is the risk?
It is a special purpose entity that is issuing the bonds. You're correct at that. That there are indemnifications from DEP to that SPE. So the risk would be securities law risk is what I'm referring to there. So we can only market these transactions through a registration statement that's been issued or approved by the SEC. And so we, as at the SPE, ultimately DEP through the indemnifications that DEP makes to the SPE, will be responsible for all disclosures in that registration statement. And so if there's misstatements of fact, if there's omissions or anything like that, that liability would ultimately come to DEP. That's the law. That's the liability I was referring to.
Okay. And in connection with the question by Commissioner Caston, there was some reference to who will be able to answer the question as to why Department of Consumer Affairs and its consultant were not included on the bond advisory team. I thought I heard the comment that there will be a witness that can answer that question. Perhaps I'm wrong, but I'm looking for the name of that witness.
Chair Belzer, the council will need to speak to identify that particular witness, and we'll be happy to provide that witness's name in a few minutes.
Thank you, Mr. Robinson.
All right, thank you. That's all I have at the moment.
Mr. Heath, I have a couple of questions, if you don't mind. You stated in response to questions from Commissioner Thomas, we use underwriters all the time. We deal with underwriters frequently. You remember that
I do, yes.
dialogue? You also stated, we're not afraid to challenge underwriters. Explain that to me, would you?
So, we recognize that underwriters are, they're, everybody in a transaction, capital market transaction, the investor, the underwriter, the company, are all looking out for their interests, right? We as the issuer want to get the lowest interest rate we possibly can. The investors want to get the highest interest rate they possibly can. The underwriters want to make sure the transaction can proceed through the market in an efficient manner, and they want to earn repeat. They've got relationships with the investors, and they also want to earn repeat business from the issuing entities. So all those dynamics are there in any bond issuance transaction, whether it be a first mortgage bond at DEP or whether it be in this storm recovery bond issuance. So when I talk about pushing back on underwriters, we get indicative pricing levels, right? This transaction, whether again storm recovery bond, first mortgage bond, we think it's going to price at this level, right? And so we need to understand what is in those assumptions. How are they getting to that rationale? Where they expect those bonds to price? Show us what are you comparing this to? First mortgage bonds and things like that's pretty clear, right? You can find another similarly rated first mortgage bond issuer, another opco that's maybe in Georgia or Louisiana or wherever, right? That's similar rated, and say, okay, well we should be trading in that same range. With the storm recovery bond, it's a bit different because there's not very many AAA rated corporate entities out there. There's two really at this point: Johnson & Johnson and Microsoft. Some people would put Apple into that category. Apple has has a AAA rating from one agency and a AA rating from the other. And so there's a limited population of corporate AAA entities. So when you think about what are the pricing comps for a storm recovery bond, some of that might be those AAAs, but again, there's limited number of AAAs out there. All those entities have a lot of debt outstanding, but the number of issuers is small. There is the asset-backed security population, which we are adamant that this is not traditional ABS. This is not things like credit cards and auto loan portfolios.
Well, I'm glad to hear
like
that.
It's absolutely not.
I'm glad to hear that statement.
So, we need to understand when they come up and say, when they give us an indicative pricing sheet, we need to know what's in or give us indicative pricing. We need to see the support behind that to understand how are they getting to those levels that they're showing us. What are they measuring it compared to? And if they're not measuring to the right ones, we need to guide them to get to the right comparison.
And that's what I reckon where I'm coming from. If they come in and say, we need to price these bonds here, and after discussion, Duke and the bond team after discussions think that it should be something else, is there going to be pushback or say, well, we'll ask somebody else? Or
absolutely.
I mean, that's where I want some comfort level.
Absolutely.
That
yes.
We're not going to necessarily accept the first price that comes in the door.
Right.
Okay.
Correct.
I mean, I think we're in agreement here. The amount of money to be recovered has already been set, right? I mean,
the storm recovery cost
right.
has been.
What has been approved
right.
for Duke Energy Progress to get back through these bonds has already been set.
Correct.
Duke wants the money. The commission approved an amount. The commission wants Duke to recover that amount through the issuance of this bond. Where we are now is that language of the statute that says that the pricing of the storm recovery bonds will result in lowest storm recovery charges consistent with market conditions. And that's what everybody needs to be on board right now.
Absolutely.
Duke, ORS, DCA. Everybody's on board with the lowest. And so I want some comfort level that, yes, we are going to go in there and push back and fight to ensure that the ratepayers are only paying or they're paying the lowest charges at the market conditions when these things are priced. That's what I want an assurance of.
And ultimately, that comes to you by way of the issuance advice letter and the certifications from DEP and ORS and the
And I agree
and
with
the
that,
underwriters.
but y'all got to push back to get that
Correct.
to get to that point.
Correct.
You
Yes.
agree with that?
Yes.
Okay.
Yes.
And
That's our job.
You've been doing this you were involved in the Florida transaction and in the North Carolina transactions.
That's correct. I was involved in Florida from this stage of the transaction through, and then I was our lead treasury representative on the North Carolina transactions.
And I also noted that in your this kind of came out when you were discussing having engaged Goldman Sachs as the structuring agent, I believe is the term. But you indicated that, and I put it in quotes, that Duke is wanting the best deal for customers as possible. Is that the mandate here? Is that what
That
y'all?
best deal to me is the lowest storm recovery charges consistent with market conditions.
Okay. All right. Thank you very much. That's all I have. Commissioners, Commissioner Caston.
Okay, okay. Chair Belcher actually generated a couple of thoughts, questions too, relative to that market. I think you were talking about asset-backed versus corporate markets. And so, which is the larger market?
Corporate bonds is multiple of the size of the ABS market.
So, I'm just an engineer, but when I think about size of markets or whatever, if the corporate market is larger, would there not be greater opportunity relative to size of market versus a smaller market?
I think there's greater opportunity in and to be able to get to the statutory objectives in the corporate market. Well, by attracting the broadest spectrum of investors into this transaction, there will be people who buy ABS products that come into this transaction. There will be people who buy municipal bonds that might come into this transaction. There will be people who buy corporate bonds that come into this transaction. So our goal is to make this appealing to the largest number of investors, because the more bids we can get into the book, the more leverage we have to tighten the pricing and reduce the interest rate on these bonds. So we got 176 million is the number that we put in my rebuttal testimony. So the 170 of the underlying storm cost plus our estimate of upfront costs get us to that 176. So if we can go do our marketing efforts and we can get orders into this book of $400 or $500 million, we can then use that leverage, that demand, to start tightening in the price and get to a lower coupon, right? If we can only get 170 million or 180 million dollars of bids in the book, we may not have that leverage, because if any one person leaves, then we may not have 176 million dollars of bonds sold.
Does that matter?
Yes.
Can the underwriter not acquire what's remaining?
You can talk to Ms. Niehaus a little bit more about what circumstances they may be willing to buy or hold unsold bonds, but it would be, to my experience, is very limited situations.
So is it in Duke's best interest if the bonds are sold quickly?
No. Our goals in this transaction is to get the lowest storm charges consistent with market conditions for our customers and recover our costs. That means an efficient transaction. It does not mean a poorly executed quick transaction.
Okay. Because my interest as a commissioner relative to this particular act is that same thing, to achieve the lowest cost. Now, if it is 10 basis points difference or 100 basis points difference or 150, who pays that difference?
What do you mean by paying the difference?
Well, I'm talking about whatever the rate is. Like, you know, if we'd have worked a little bit harder, we might have could have gotten another 0.1% off. Ultimately, who will be paying for all
Customers are paying for service in this debt. Absolutely.
Right, not new. So I can't speak for the others, but I believe this is the case. We're trying to assure that that is absolutely the case, and I hear what you're saying, and I'm not doubting what you're saying. But when I think about our primary role to look after the customer in this particular act, and DCA's specific role to look after the customer, you can understand why I would want to make sure that we're all on the same page. Do you?
I do, and I believe what we've put forth in the settlement, particularly with the constructs of the bond advisory team, provides just that for you. It provides when we deliver an issuance advice letter at the end of after pricing of the bonds, and there are certifications from DEP, from an underwriters, and from ORS that we've achieved those statutory objectives. I believe you can take comfort in that we have in fact achieved those statutory objectives. We take that certification, and Ms. Niehaus can speak to, you know, how seriously Goldman Sachs takes making a certification, and the ORS can talk about how seriously they're going to take it. But we take that obligation to give you a certification that we've met those statutory objectives extremely seriously. Like we don't give this certification in any other debt issuance that we do, right? So
Now,
we take this obligation extremely seriously.
and a lot of talk about underwriters, and you mentioned Goldman Sachs again. That the underwriter selection has not been decided, correct?
Correct.
And will it be just underwriters that Duke is familiar with and has worked with, or will you cast a broad net?
It's going to be underwriters who are capable and experienced in executing utility cost recovery bond transactions in a very successful manner, providing value and savings and lowest storm recovery charges to customers. So it's you know, we've done that. We're comfortable that Goldman Sachs is a party that could do that, based on our discussions with them in our RFP that we conducted for the structuring agent role. Because again, I mentioned earlier, we've asked some questions about underwriting capabilities in that RFP. We know other banks that we worked with both in Florida and North Carolina that are very capable in this space, and we know co-managers that we've worked with. So kind of that second tier of underwriters that we worked with both in North Carolina and Florida that that are very capable in this space, that can bring in incremental type orders that maybe the large banks don't cover. So we're not biased in any way to particular institutions, and so as we go through the bond advisory team process, and if ORS and DCA want us to, you know, do RFP type things, and they have suggestions about firms to consider in those RFPs, we will listen to that. We'll listen to those perspectives.
Okay. Thank you, Mr. Heath.
Are you through? Commissioner Justin Williams?
Thank you.
Morning.
I'm going to try to be quick. I'll listen to your testimony. I think I understand it. I appreciate it. You talk about the bond advisory team, and I understand the formal members and the informal members. My question to you is, who leads the team?
So it would be the company leading the team, and so we would put together agendas for every meeting. But as in terms of putting those agendas together, we would coordinate with ORS and the other members to agree on topics to be discussed at each meeting. But we would be the ones who would be overall coordinating those meetings, putting together materials, circulating those, leading that discussion. But again, always soliciting advice and input from all of those parties to make sure that we're aligned as much as we possibly can be as we proceed through all those steps of the structured marketing and pricing of the transaction.
Thank you, sir, for your answer. And I'm going to ask a question that I think was asked several times, but your answer was not direct enough for me to understand it. So I'm going to ask it again. And I think Commissioner Cass then asked about the underwriters, which underwriters you all would use. He asked you whether or not it has been decided, and I think you said no.
Correct.
And then I think he asked you what would happen if ORS or the DCA or anyone else had a suggestion. You said you would listen to those suggestions.
Correct.
Okay. And that's good. But then what happens next? If ultimately you don't agree with those suggestions, what happens next? Do you, as the leader, do you get to say, thank you for offering, your suggestions have been heard, but we're going in this direction? Is that what happens next?
That would be the case if there were disagreement, and we would need to provide a reason for that disagreement. We wouldn't just tell any of the parties, we're just not doing that, right? We would provide them with our basis for why we're making the decision that we're making, and so we would not dismiss any suggestion just out of hand without providing a reason as to why.
Right, I understand, and thank you for going through that with me. So, as a formal or informal member of the bond team, would you then expect for them to inform the commission of that difference of opinion in some way? Or would the commission receive that? Well, let me ask a better question. How would the commission know that a suggestion has been made and denied by the leader of the bond team? A suggestion has been made by a member of the bond team, formal or informal, and ultimately that suggestion was denied by the leader of the bond team. How would the commission know that?
I presume, we've contemplated in the settlement agreement that after we file the issuance advice letter, there would be an opportunity for the commission to ask questions. And so I think maybe those could be questions that you might ask at that point. I don't think we've contemplated, periodic report outs or anything like that to the commission on the status of the bond advisory team. But these are, I want to just kind of maybe level set a little bit. I mean, we're talking about, there are big decisions to be made here. There's also very, very small, I wouldn't say inconsequential decisions, but there's smaller decisions and there's much bigger decisions to be made, right? And so one of those much bigger decisions is when we get to that pricing time, where are we going to? Where do we say that this is the best outcome we can get for customers on this day that we're at this time that we're in the market, right? That's a huge decision, and that decision, in my mind, there can be no disagreement on that, right? Absolutely no disagreement. ORS, us, the underwriters, DCA, we all need to be looking at each other, staring each other in the eyes, and saying, we agree. This is where we're pricing this transaction.
I understand that. I want to ask you to slow down for me a little bit because I appreciate what you're doing. I understand. I learn better when examples and explanations are given to support those examples. So to that particular decision, the ultimate decision, if you will, how much time do you think you have to pull the trigger on that decision?
Not a lot. So, this type of transaction. So we think, I want to contrast this transaction to a DEP first mortgage bond transaction. So we, on a first mortgage bond transaction, we're working with underwriter. We select a group of underwriters for that transaction a couple weeks before we expect to put that transaction in the market. But we have a market update call, and we said we're going to put the deal in the market this week is our ideal timing. So we gather today. We have a call with this group of underwriters, and we understand the market backdrop, what's been happening overnight around the world, what do futures look like, what are we expecting in terms of economic announcements or anything happening today that would impact our decision to actually launch this transaction or not. If we say we're moving forward, by 9 or 9:30, there's an announcement that DEP is issuing, let's say, $500 million of first mortgage bonds today. And those underwriters that we've lined up are contacting them. First, that's blasted through Bloomberg. And then those underwriters are calling their accounts and touching base and, gauging demand and interest. And by 11 o'clock, 12 o'clock, we've got a filled order book. All right, so we're selling $500 million worth of bonds. We've got orders for somewhere north of $500 million. It depends on the market. It depends on the entity. It depends on how much debt DEP already has. A lot of factors that drive that level of demand. But we know, by 11 o'clock or so, what that book is looking like. And we go back out and we when we first announced it, we gave some, we call it initial price thoughts. This is a 10-year first mortgage bond for DEP. We expect to price this at treasuries plus 120 basis points, right? 1.2% above treasuries. And as we go through and we build that order book demand, we look at the orders around 11 o'clock, and if we're sufficiently subscribed and we know the constraints and the demand and the sensitivities in that book, we work with the underwriters to say, okay, go back out and now give guidance to the market that the price is no longer treasury plus 120 basis points, is treasury plus 110. And we make that announcement, and some people may cut their orders back. There may be incremental orders come in. Some people may leave the book altogether. And then we go through the next stage. And so, but by 12:30 or 1 o'clock, we've maybe cut back pricing again, and now it's 10-year treasury plus 100 basis points. And we say this is where we're pricing if we're confident that that deal is going to be able to sustain that pricing cut. And then we set that pricing, we set that spread rather, and then we work with the underwriters to finalize allocations of those bonds. So this customer this investor put in a $100 million order. We're going to give them $75 million of bonds or $50 million of bonds or whatever to get to that $500 million that we're actually going to sell. We work through that allocation process, and by 3 o'clock in the afternoon, we get on a phone call with all those investors and with the underwriters, and we get a quote of the 10-year treasury rate, and we add the 100 basis points to it, and that deal is done, and a couple of days later we get cash in the door at DEP. Transaction like this is not going to happen one day, most likely. We're going to decide through the bond advisory team process, when do we want to launch this transaction? And on that initial launch day, we launched the transaction. And this is after we've done a week or a week and a half, maybe 2 weeks of investor discussions, right? So this is a different credit than the Duke Energy first mortgage bonds, right? Duke Energy first mortgage bonds have a standing credit rating, And the people who buy those bonds, they're going to buy them or they're not, right? Whatever their portfolio looks like. In this bond, we've got to go out and meet with investors to, one, maybe do some re-education of recovery bonds, because there's been transactions that were done throughout 21 and 22 that were done by some municipal issuers, some co-ops, other regulated utilities, and we need to make sure that folks understand this is a regulated utility offering, a DEP-backed offering. It's not a muni, it's not a co-op, right? We need to discuss the strengths of the DEP South Carolina service territory. Right? What is the customer base? How much residential? How much commercial? How much industrial? What does this charge look like on customer bills? Bondholders and rating agencies are very concerned about that. And so we're going to do this extensive marketing process. We're talking about the robustness of the true-up mechanism and how that mitigates credit risk. This is a AAA rated bond. All these features of the bond stress the importance of it. Bankruptcy remoteness, it's got a non-bypassable charge, a non-appealable financing order, a state pledge, all those things that make this bond what it is. And so we'll go through that lengthy marketing process. And then at some point we put the transaction into the market. In contrast to that Duke Energy First Mortgage Bond, very likely that this is not going to price out in one day. So we're going to launch the deal on a Monday, and we're going to have to field, along with the underwriters, questions from investors. So we had that marketing process with them. We've given them the strengths of the bond. We've pitched them the credit, and now they want to do some analytics around this bond. And they're going to do that during this kind of marketing process, this official marketing process. And so this may take 2 to 3 days from the time we announce the transaction and to the time that we can actually price it. So as we're gathering orders, the underwriters are talking to investors, the co-managers are doing their work, going to their smaller accounts. And we build that same book that we build on the first mortgage bonds, but it's a more extended period of time because a lot of these investors have to get credit approval for this particular bond because it's a new bond and it's got some structure around it that the first mortgage bond doesn't have. But we go through those same milestones, initial price thoughts, and we all have to agree on that as part of the bond advisory team. Guidance, hopefully cutting those initial price thoughts down to maybe cut it down a second time, right? And then ultimately to pricing levels. So that's going to be a multi-day process. But as we go through those steps, there's going to be continuous dialogue with the bond advisory team. What we did in North Carolina was, we had this morning diligence call with the underwriter group. We made the decision to put the transaction into the market. We had talked about all the week before about what initial pricing thoughts were going to be. And so we were all synced up on that. We agreed this is the day to launch this transaction. And as we went through those several days, we had ongoing dialogue. We would convene bond advisory team calls within, as you're going through this book and it's building dynamically, it's like, hey, we're having a call in 30 minutes. Like, make sure everybody that needs to be on this is on the call. And so we would get on the call with the underwriters and the full bond advisory team. We would talk through the status of that order book and understand, what is the level of subscription. So we're trying to sell 176 million. Where are we at? Do we have orders for 50? Do we have orders for 170? Do we got orders for 300? Where are we at? And what do we think we can do on pricing? Can we trim it 5 basis points, 10 basis points, 15 basis points? Do we need more time to continue to work through the process? There's, underwriters will know as who they're talking with and have they, what is their likelihood to come into the book and have they come in yet? Or have they said they're going to come in, but they've still got some credit work to do. So we have to understand all of that dynamic and make decisions along the way. So ultimately, once we've gone through those processes and we've collected orders and we've trimmed pricing, hopefully multiple times, we get to the point where this is as far as we can go. Right? And
May I stop you there?
Sure.
How do you know that is as far as you can go? Who makes that determination?
It's a collaborative process. So just like everything in the bond advisory team, we're going to be hearing from the underwriters where do they understand this book to be, and what are the pricing sensitivities, and we're going to need to do diligence on that. This whole bond advisory team will have to say, okay, well, show us the facts, right? Show us what are you basing these comments off of, and how do we know that investor A, they've got a $50 million order in, but this is as low as they're going to go, right?
So when that, and I'm sorry to interrupt you, when let's say everything works well the way that you want it to work, and you bring the matter back before us for final approval, and there was a disagreement between you, the leader of the bond team, and the member of the bond team, a disagreement that looks like a suggestion that was ultimately denied by the leader of the bond team. Maybe it could be, we think you could go lower, we think we could cut more. They make that suggestion, and that suggestion ultimately is denied. What I'm hearing from you is that there's going to be some level of offer or evidence to support why that suggestion was denied, right? Okay. And I would imagine a member of the bond team wouldn't just make a suggestion just to make it. I'm sure they would have some support why you could go lower. So do you believe in a situation like that, and I know it's a loose hypothetical, but in a situation like that, do you still think that you could support the deal that you bring before us as the least cost to ratepayers, even though there was a suggestion that you did not take?
I think it depends on what those disagreements might be, right? As I think I started off my my fairly lengthy comments in response to your question as, when we're talking about pricing, and ultimately where are we going to price this transaction, there can be no disagreement. Like, we have to be on the same page that this is the pricing level, and this is where we're all comfortable pricing this transaction and delivering our certification. If we're talking about,
let's slow down there. If that's the case, what I hear you saying there then is that if someone believes that we could go lower, that you all could go lower with the price, that's going to be a consideration that's going to be taken, and you're going to try to go lower. Is that what I'm hearing?
If someone has that perspective, we have to listen to it, and we have to carefully consider it, because if leaving basis points on the table is not lowest cost, is not lowest storm recovery charges, right? And so again, we've got to be aligned on that, and so we have to understand all throughout that whole multi-day period. That's why we're going to convene the bond advisory team half a dozen to a dozen times during a 3-day window, right? To say, okay, here's where we're at. Here's the check-in for today. Here's the morning check-in today. Here's the afternoon check-in today, and then here's another call that got scheduled in 20-minute notice on Monday afternoon or Tuesday afternoon, so that we all understand the status of the deal at every time, every moment, not every moment, but as we're moving through those decision points, right? And so we have to understand that. So we all have to be on it. So if we're in agreement as we move through, hey, this is looking good, or no, this is struggling. We got a lot of work to do over the next 2 days. If we can have those agreements, you know, when we get to pricing time, we should all be well aligned as well. But if someone thinks that, hey, we're at this point where there's another 10 basis points to be had here, well, where do you see that, right? Because we've been talking about this for 3 days. You know, this particular aspect we've been talking about for 3 days. Like, what's your rationale for thinking there's 10? Maybe there's 5, right? And so we
So if there's 5, do you try to go get those 5?
Yeah. Yes.
Okay.
Yes.
So I'm done with that line of questioning. You answered my questions to my satisfaction. I appreciate that there. I want to talk about the quantifiable net benefits. Is it fair to say that once that certification is issued, that ratepayers paying for these storm costs through securitization will receive savings compared to paying for storm costs through a general rate case? Is that an absolute, undeniable, guaranteed fact?
Absolutely, yes. There's these 2 statutory objectives: quantifiable benefits, lowest storm recovery charges, right? And it's almost the quantifiable benefits is the starting point, right? If we can't demonstrate quantifiable benefits, we don't go forward at all, right? If we can demonstrate benefits, and then when we filed our petition, we said there's $41 million of benefits here to customers, right? Now, and that's why we filed our petition, because we saw that level of benefits. And so now the work, post financing order, is to meet statutory objective number 2.
And so even if there is some level of disagreement, I hope there's not, but let's say there is some level of disagreement about pricing the bonds and whether or not there's more savings to be achieved. Maybe reasonable minds can differ. I don't know. I'm not going to be there, but let's just say there's a difference of opinion. Even if there's a difference of opinion and there's a suggestion that you decide not to accept or explore, if you come back and you certify that the deal you have not only has quantifiable net benefits, but you believe it's the lowest cost to ratepayers, but there's some disagreement there, even that deal or that pricing of the bond will lead to savings to ratepayers as compared to paying for the storm costs through a general rate case.
Correct. And as I laid out in my direct testimony, we did some sensitivities on savings, right? So the base case that we put forth in there was the $41 million of savings. We showed a break-even interest rate of something like 7.75%, right? Hopefully we never get anywhere near that, right? Hopefully we're talking about a deal here we are September 11th, right? We're talking about a deal that's in the market no earlier than probably the end of February 2024. A lot can happen in the next 5 months, 6 months, right? But I hope we never see any interest rates that are 7.75%.
Is there any risk to lose? And I'm using deal loosely, but is there any risk in losing interested investors by attempting to explore too many options to get the lowest possible savings to ratepayers? Is there a point where you may be throwing good money at bad money?
Yeah, there's and this, pricing of a debt security in the public markets, like we're talking about here. it's an art, right? So it is based on the dynamics of the order book for the particular deal at the particular time that you're in the market, and it's driven by, you know, the market conditions. It's driven by investor demand. So yeah, it's you know, there, as you go through that whole, as I talk about this kind of probably likely 3-day pricing process, right? Launch to price. You know, the investors are like, you got a few, you know, you start out with this initial price thoughts, you offer guidance, another round of guidance. Price is kind of what we did in North Carolina. But you know, you know, initial price thoughts, reduced guidance, reduced guidance, reduced guidance, reduced guidance, reduced guidance, like multiple, that doesn't really work, right? You really have to understand as you go through every one of those movements, what is the sensitivity in the book, right? And as you make those cuts, you know, that proves out, right? I mean, if you reduce by 10 basis points and nobody goes away, and and you've got the same number of orders that you started with, well, that's a pretty good indication that you got more you can cut, right?
Do you start cutting until people walk away?
Generally, as reductions happen, there are either people who walk away completely, or there are people who cut back their orders. So somebody came in and said, I really like this deal. I want $100 million, $100 million, and there's some gamesmanship going on there, because if they're saying they want 100, they probably really don't want 100. They might want like 75 or 50 or something like that. So because they understand how the pricing process and the allocation process works. That, you know, if we're selling $176 million worth of bonds and there's $600 million of orders out there, somebody with a $100 million order is not getting $100 million worth of bonds, right? So they factor that into their offers, into their bids, and so, but yeah, you know, as pricing tightens, there can be complete orders falling away. There can be reductions of orders.
Thank you, sir. Madam Chair, that's all I have.
Thank you, Commissioner. Commissioners, further questions for this witness? Commissioner Carolee Williams.
Thank you. I hope you have enough water, Mr. Heath.
I'm getting low, but I'm okay.
Well, now your team knows that. Would you agree that the statute allows the commission to impose any other conditions not otherwise inconsistent with the securitization statute?
That is the language in the statute, yes.
How does that relate with the settlement agreement? And I realize asking you that may be more of a question to a lawyer, but you've participated in these in other states. Have you had settlement agreements?
We've had, Florida. That was 2016, so that was 7+ years ago at this point. And the preceding part of that was a year before we did the deal in 2016. So that one's a little further back in my mind. I don't recall specifically what type of settlements might have been there. In North Carolina, I believe we had a partial settlement on some of the things like, what do we do if the actual amount of upfront financing costs are more or less than what we estimate in the IAL, and things like that. So nothing that was comprehensive as what we're proposing here.
But would you agree that based on the statute, if there's I'm sorry. I'm thinking as I talk and thinking maybe you're not the person I can ask this question of. Would you agree that it's a conundrum what we look at outside of this settlement agreement based on the statute that we have in this state?
You know, there's definitely that language in the statute for any other, you know, as you read. You know, I feel the settlement that we've put in, that we're putting in front of you and asking you to approve is, you know, has sufficient, you know, specificity on how the bond advisor team is going to operate, who's on it, and other things that we talked about, rating agencies, the give back of ADIT, and all of those things that are comprehensive. And I mean, I don't see there would be a reason for other conditions, but that's that's within your purview as the commission.
Okay. Thank you. No further questions.
Commissioner Thomas?
Thank you. So just carrying the conversation with Commissioner Justin Williams a little bit further. So you were talking about the working down to the appropriate rate. So basically when you're building the book, you're hopefully going to begin, from hearing what your discussion was, hopefully you're going to begin where you are oversubscribed.
That would be that's the hope, right? That we have orders for far more than $176 million.
Okay, and so basically what that means, if you are significantly oversubscribed, then the investors think this is a great deal for them, great interest rate, which the other side of that is that it's not a good deal for the ratepayers because they're paying too high of an interest rate.
Yeah, I don't think it automatically means that. I mean, that could maybe be implied, but there's a lot of context that needs to be understood in terms of the status of those orders and what sensitivities are.
But then as you work back down a few basis points, step at a time and so forth, is it possible that being slightly or becoming slightly undersubscribed is the best deal for customers? Let's say, I don't know what the number is, 98%, 95%.
I think there's a difference between a deal that is $176 million and we've gone through an extended pre-marketing period, as I described to Commissioner Williams, and then this multi-day book building process, and that deal only has $174 million or something south of 176. Then a deal that had orders and we trimmed pricing and we trimmed pricing again, and then we announced the actual pricing level, and that was somewhere north of 176, and then it turned into 170 because we drove someone away. I think those are different situations, and I would suspect that that underwriters would look at those deals much differently in terms of their appetite to hold unsold bonds.
Okay. So let's talk about ensuring that the underwriters reach out to the widest range of customers. I mean, you've mentioned that there's a lot of repeat business, and they like working with people that they're familiar with and have done deals with and all of that kind of stuff. But again, the widest range of potential investors is probably what's going to result in the best deal for customers.
Right.
So is there anything that Duke does or proposes to do to ensure that the underwriters reach out to the broadest range?
Yeah, so we'll do a fair amount of things. So a couple of these will be, we'll look at the holders of our existing deals in Florida and North Carolina. We'll compare that to people who hold Duke Energy first mortgage bonds, whether they be DEP or DEC or any other Duke Energy affiliate. We'll identify people who are in maybe first mortgage bonds that haven't bought a storm recovery bond or a cost recovery bond from us in the past. And those will go on our target list to go hit on for this deal. We'll look at who bought our deal compared to who bought SoCal Edison or other deals that we think are the best executed deals, and find people who were in those deals that weren't in our North Carolina deal or not in our Florida deal, and go add those in our targeted investor list. We'll look at people who bought, maybe that are in those AAA corporates that I talked about that maybe haven't historically bought a Duke product. And so there's a number of investors that will just be on the list because they've been in the Duke deals before, but then we'll go through efforts to identify people who haven't bought either a Duke first mortgage bond or a Duke sponsored utility cost recovery bond in the past, and make sure that we go and actively consult with them too. Our marketing efforts in both North and South Carolina, North Carolina and Florida, we did multi-day investor calls. We talked with north of 80 potential accounts, unique accounts. We as the company did. The underwriters and the co-managers talked to others themselves, but we hit 80 accounts ourselves over one-on-one calls, small group calls, 2 to 3 to 5 investors at a time. We recorded a roadshow presentation with slides and a script, reading through slide by slide what was on those slides and the credit features of the bonds. And so we hit 80 accounts, one-on-ones or small groups, and then the underwriters and the co-managers talk to other unique accounts as well. So we'll do that same level. We talked to 80 accounts for a $1.3 billion issuance in Florida and 80 accounts for a $1 billion issuance in North Carolina. I don't see us talking to anything significantly lower than that, even for a $176 million transaction.
Okay, and as part of that, on the part of the company and the underwriters, would there be some specific interest towards trying to attract investors from South Carolina?
Are you asking in terms of institutions in South Carolina, or are you asking about retail individual accounts?
Both.
So certainly on the institutional front, absolutely. On the retail side, I think there's only a couple of these deals. I think Ms. Niehaus can speak a little bit about the specific deals that had any sort of retail distribution. But my understanding is that, retail distribution requires additional state level registration. So that's some added cost to that. So I think if we were looking at retail distribution across the country, I would say that's probably cost prohibitive. Probably doesn't add enough value. If we're talking about just registering to do, retail marketing in South Carolina, I think we could probably justify the cost of that. With all that said, though, I don't know that that's going to meaningfully add significant orders and pricing benefits. Generally, whether it's a small institutional investor or a retail account, those orders are going to be smaller, and they're not really going to be setting price. They're going to be folks who are likely taking the price that's cleared. So we could do retail distribution, slightly added cost, some benefit, I think, but probably not enough to truly impact pricing positively.
But there are some firms that do specialize, obviously, in small retail accounts. And would you anticipate that the firm itself would be interested in participating in getting involved with the more detailed marketing to their smaller individual investors? Is that kind of part of the way this thing works?
It's not something that we did in North Carolina or Florida, but again, we could pursue it here in South Carolina. But it would have to be a broker dealer that would be specifically targeting South Carolina retail investors. That would have to be looped into the transaction.
Well, that may or may not be worth pursuing. Just thinking about it. So there was a big change in the estimate for the upfront costs that went, I don't know, 30% increase in the upfront costs that were estimated. And I don't have the details in front of me, but that's a big number. And one that stands out to me, I believe, was I think it's the servicing cost that is anticipated by the special purpose entity. It seems to me like that went to, I can't remember what the number was, but it was a really big number. Can you help me understand why that got to be so much more substantial?
So I'm looking at my rebuttal exhibits right now. These are Exhibit 1. So the servicing costs is a component of ongoing expenses, so not the upfront issuance amount. And what we're showing there is we've got on both upfront and ongoing, we show a range of expenses, a low end and a high end. And the low end, the servicing fee is $88,000 a year. And that is estimated at, I think it's 5 basis points of the principal issuance. And that's consistent with both our prior deals in North Carolina and in Florida and most other deals that I've looked at in this space. The bigger number that you're seeing is if for some reason Duke Energy Progress was no longer the servicer of these bonds. So there's an agreement between the SPE and the utility that DEP is going to service the charge. We're going to set the charge, file true-up adjustments with the commission. We're going to put these charges on customer bills. We're going to collect the cash. We're going to send that cash over to the trustee to be held for payment on the bonds. In a very unlikely scenario that DEP would not service these bonds, that $1 million fee is for hiring a replacement servicer. There's been no transaction that I'm aware of where the utility did not continue as the servicer of the bonds.
Well, I guess my concern is again, coming back to us and the assurance that this is the lowest cost for customers. And that concerns me that what's to keep that from happening, because that's a significant difference.
I believe our financing order has some language about DEP continuing to be our proposed financing order has some language about DEP continuing to service the charge. We have no expectation that we would not be the servicer throughout the life of these bonds.
Okay. So,
and that's a standard. I don't mean to interrupt you, but that structure we've laid out there, this 5 basis points for the utility to be the servicer, I think it's 60 basis points for a replacement servicer. That is pretty standard in all of these cost recovery transactions.
All right, so let's talk just a little about, I think you mentioned somewhere in your testimony that you would anticipate this being a single tranche. And so I'm just wondering, how did you reach that conclusion? Would you be considering perhaps more than one?
We will definitely, as we go through time and we go through the bond advisory team process, we will be looking at whether the single tranche makes the most sense, or would it make sense to cut this up into something that maybe is a 6 or 7 year weighted average life and another bond that's 14, 15 years, or whatever the math happens to be, to cut this into 2 tranches. But when you do that, you're taking that $177 million and you're cutting it up into 85 and 85 or something, right? And you have to think about, are we going to be able to get folks interested in two $85 million deals? Because those are typically on the shorter spectrum, in our experience in our North Carolina and Florida deals. Those shorter weighted average life deals typically attract more interest from traditional ABS investors, and those longer tranche deals are the ones where the crossover corporate buyers really come in. So we think this 11.8, 11.9 weighted average life is a good structure that gets both those investors into the book, both those types of investors in the book. If we break that into the 2, there's a lot of credit work, as I was talking in my response to Commissioner Williams earlier. A lot of credit work that needs to be done for investors to think about buying these bonds. A lot of analytics, looking at detailed rating agency reports, running their own kind of models and simulations around the charge and default risk and those sorts of things. And so, 2 $85 million deals, considering the level of work that's got to be done, credit work, might not be as attractive as a $170 million deal to an investor. We have to weigh those considerations.
Right. And is that something that in part happens when you're building the book? Is that when those kinds of considerations are happening, or what?
No, those will be determined in the earlier stages of we're going to be talking about that early on and all throughout the process. One tranche versus 2 tranches or something else. Ultimately, where we start landing on what are we actually putting in the market is as we go through that. I talked about this 1 to 2 week kind of pre-marketing phase, and we start meeting with investors and we talk about this statute and this financing order and DEP service territory and all the unique credit aspects of this deal. We'll start engaging investor feedback at that point. Do you like shorter term? Do you like longer term? Does 11.9 look good to you? And we'll kind of gauge that appetite through that process so that when we go, before we launch, we can revise our registration statement that says 1 tranche versus 2 tranches. So that what we launch is what we ultimately price.
Okay, thank you. I appreciate that.
Commissioners, any further questions? Ms. Athens, any redirect? Are we going to be here long? Because we haven't given y'all a break all morning, and it might be. Do you want to proceed before lunch, or you want to?
I'm.
Let's break. We've been going. I'm up here drinking water. So he is too. He may need a break. We need to come back at 2:00. We need to break this afternoon for the afternoon about as close to 4 as we can. I need for council to get together and look at your list of witnesses that need to be taken today and see if we need to do some rearranging of the order of witnesses, if you would. And if y'all would notify us of that at 2:00, and we'll come back for redirect at 2. Thank you very much. Y'all have a good lunch.